November. It's a matter related to eviction. However, my lord, the matter is not listed. We like to seek the permission of this court to be listed today, as the matter may become infructuous, since the matter is related to eviction, my lords.
Today will be some difficulties will be there. We'll have it on Tuesday.
Okay, much obliged, my lords.
May I please, your lordship? My lord, I am praying for listing this interlocutory application, my lord, for consideration of delay, my lord, in the writ appeal, my lord. Consequential order has been passed by the authority, my lord, pursuant to the honorable single judge order, my lord. The writ appeal is pending, and notice was issued on, my lord, 11/9/2023 in the condemnation petition. Can it be taken up in the next week, my lord? My lord, I am also mentioning, my lord, item number 5. I have taken consent from the other side, my lord. Lordship may adjourn the matter for 4 weeks, my lord.
On request made by Mr. Saikel and the counsel for the petitioner, list up to 2 weeks.
My lord.
May I please, Lord?
Mm.
May I please? I beg to mention item 6.
Six.
6. I yesterday have given an adjournment slip. I've taken consent for the other side also.
Okay.
If the Lordship may convenient the matter is in the first week of the December. And if
Who appears on the other side?
other sides,
Appellant?
P. Mohanta and R.V. Fugan, they have taken consent.
Okay, on request made by Mr. H. Chakri, then counsel for respond number
No, correspondent 1.
1. List the matter. When? First week?
First, if you need not 7th of December.
6th. 6th December.
There is some interim order, it may be.
Interim order possible.
Obliged, I get.
11th.
Yes, sir.
11th.
Obliged.
Wait, please, your lordships. I beg to mention this matter not in today's list, but it was filed on the 31st. Subject to the convenience of this honorable court, if it may please be taken up on Wednesday.
Fresh listing?
Yes, my lord.
Okay.
Deeply obliged, Lord.
Your Lordship, I have a similar prayer, Your Lordship. This is a writ appeal. Your Lordship, we have been terminated and the termination order was upheld by the Honorable Single Judge. So our post may be advertised any moment, Your Lordship. So I have already filed the cases. May I pray that?
When did you file it?
One case I have filed on is 10th now, on 8th, and the other case I have filed today. On Wednesday, Your Lordship, there is a delay condonation application also, so the delay has to be condoned.
Friday.
Can it be on Wednesday? Because, Your Lordship, the delay has to be condoned. I'm not on that. If the delay gets condoned, only then that will be listed.
Notice has to go on the delay, isn't it?
So the state will appear, Your Lordship. If they concede, in that case, that can be listed again.
Okay.
Wednesday. Deeply obliged, Your Lordship.
May I please, your lordship? I am praying for lordship listing one writ appeal, lordship. Filed on 29, lordship. Can it be on 15th, lordship?
20.
20, lordship. And another lordship for consideration of delay, lordship. That is filed. That is also regarding writ appeal.
Same day. Same day.
Obliged, sir.
May it please, my lords,
Yes,
I'm
yes.
praying for listing of a fresh writ appeal, my lords, on Wednesday, 15th. But there is some urgency in the sense, my lords, the challenge is to a order passed by the learned single judge granting interim against invocation of a bank guarantee. Because in the interim, the bank guarantee will expire, my lords.
When is it expiring?
My lords, it will be expiring on Monday or Tuesday, my lords. Well, our apprehension is that they will go ahead and withdraw the writ petition in its entirety, my lords. The order was passed yesterday. We filed it today, my lords. Deeply obliged.
Please, Your Lordship, with the consent of the others, I beg to mention item number 2, Lordship. Kindly adjourn the matter for a week's, Lordship.
Therefore,
Appeal and Lordship.
you good time?
K. Deka.
On request made by Gay Dev, then counsel for the applicant. List up to 1.
Value.
Item 1 of daily motion.
Wait, please, Lordship. In this case, the petitioners have instructed us not to appear further in this matter. And
What?
they have also withdrawn the brief. So, my lord, I'm praying for liberty, that we may be relieved from appearing in this matter. And my learned friend has informed me that they have not also complied with the interim order passed by this court earlier.
You have not paid the 10 lakhs.
No, that is.
And your lordship, otherwise the matter has become infructuous. Because they have challenged the sale notice dated 2/9/2023 and the sale has already been failed. And thereafter we have issued the another sale notice.
In view of that, perhaps my lord, the lordships may even dispose it also, because though I would not like to submit my lordship.
Without the
Lordship, yeah,
representation,
yes,
so how
that
can
will-
we dispose of the?
Lordship,
One date maybe.
my submission may kindly be recorded minutes, and another date may be fixed so that if they want to engage, they can be.
Mr.
represented.
Ganguly, learned counsel for petitioner. Submits that the petitioners have withdrawn the brief from him. And therefore press for some time to enable the petitioners to engage another counsel. Stop. Considering the same, comma. List this matters. List this matter again on 24th November.
Publish.
Respondent number 1, your lordship. My presence,
Mr.
M. Sharma,
M. Sharma. learned
for respondent
counsel,
number 1.
appears for the respondent number 1.
3.
May I please, Lordship? In this case, my lord, they have not filed the affidavit yet.
The chief secretary was implicated as a party because my lord, the rule which has been challenged is the Assam Discipline and Appeal Rules. And the education department can neither defend nor my lord, it can make a statement. The chief secretary was made the party, and on the last occasion, the government was to file their affidavit, keeping in view some orders passed by the learned single judge where the discipline and appeal rules was referred to. So it is the government who has to answer. Their names, although the
Let
order
me-
had said that their names should be reflected
Let
in the
me-
cause list, I did not find the names in the cause list.
We have served them the copy also, my lord.
There's an order where the names are to be reflected to be.
Can you catch hold of the government advocate? Bring.
I'll bring this.
Yes, Mr. Nath is there. Yes, Nath.
Well, well, we took some time. Here the rule has been challenged, Lord.
Yes, you wanted to file an affidavit.
Lordship. Well, Lordship may kindly give us further 2 weeks time. Lord.
You are
Correct.
praying for
For the chief secretary,
Chief Secretary,
respondent three.
chief secretary has been newly implemented.
newly implemented, my lord.
Yes, so respond number three.
That's one number 3. Lord.
Correct.
Lord.
Yes, Lordship. My lord, the issue in this case, my lord, with regard to my lord, to obtaining an NOC for pursuing the higher education, my lord. And as a result, what happened, my lord, those teachers who were not getting who pursued the in-service during the service period, my lord, the higher education, but did not obtain the NOC, which is a requirement under 1965 service conduct service rules, my lord. But in this regard, honorable single judge has also clarified by passing an order, my lord, stating that the NOC should, though it's a requirement, but it should not be the barrier to disqualify him for getting the charge of the principal, my lord, or the headmaster of the school. That has been already settled by the honorable single judge, my lord, in a case, my lord. Let me.
But in any case, you're challenging the rules. Let them come with the affidavit.
Rule is challenge. The rule challenge is there, but apart from that, my lord, in this line, this can be disposed of also, my lord, without touching the rule also, my lord.
How can we dispose of? We'll have to see the matter.
Let me file the
But
affidavit.
for-
Already
for
the
direction
EPS,
of the Counsel for the petitioner.
As regard the validity of the
Mr.
act, we will file the.
D. Nath, Leonard, senior governor, advocate, applying for respond number 3, praise for
Well, 2 weeks further time.
a date may give me after 2 weeks.
2 weeks time to file.
It is first week of December. Kindly take.
This, the matter on 6 December.
Lordship. Honor.
11 of supplementary list, admission.
Lordship may kindly pass over this matter for time being, Lordship.
You are supposed to file your affidavit, isn't it?
Lordship,
Item number?
Lordship, we have filed IA. We were supposed to file IA, Lordship.
Yes.
We have filed, Lordship. Senior is Lordship appearing before another
Your
court.
senior,
S Borthakur Lordship.
okay, after some time.
Lordship.
In item number 3,
Yeah.
do we miss the item because the GA Assam is not shown? Only the Standing Council Education is shown. Kindly direct follow the registry to show the GA Assam in the correspondence.
What order was passed? I can check.
Lordship has granted us time fixed on 6th of December.
Okay, okay. Registry is also directed to reflect the name of government into cost list.
Lordship. Obviously.
4 of daily list order.
Repeat your lordship.
Hmm.
Lordship, kindly take 10 days time for filing affidavit in reply, lordship.
Affidavit reply.
Yes.
Okay, MS
And the
and the learned counsel for the petitioner. Is allowed 2 weeks time to file affidavit. List of-
And for the respondent number 3.
Mr.
SS Gupta.
SS Gupta, learned counsel appears for respond number 3.
Seven.
may I please your lordship? Lordship, we have filed our affidavit yesterday.
You are appearing for
I am appearing for the respondent.
which respondent?
Lordship, Deputy
Second,
Commissioner Kacha.
Sole respondent.
Lordship.
Yes, your lord.
You file your affidavit.
Yes, lord.
Have you received?
And yesterday we have received, Lordship, we have to reply sometime maybe.
Okay, MS,
P. Tamuli, on behalf of KP.
learned counsel appearing on behalf of the sole respondent submits that they have filed their affidavit on 9th of November. Registry to verify and place the same on record. Mr. L.R. Majumdar, learned counsel for the petitioner, prays for how much time?
2 weeks.
2 weeks time to file reply to the affidavit filed by the respondent number one, by the sole respondent. List after 2 weeks.
Obliged.
Obliged.
8.
Well, the order has been complied with, the inquiry has been done and the speaking order has been passed. Look. Well, the at page 12, the direction of the Honorable Court is there.
Yes.
Lordship.
Yes.
Lordship, order was considered by the concerned authorities, but they said that it is not true, whatever allegations has been made.
They have considered it.
The
They-
Deputy
they
Commissioner, kindly
considered-
see the second last paragraph. The CPRD Assam by letter number so and so dated 27/10/23 has submitted the inquiry report received from the District Commissioner Karimganj. Karimganj, at the district level, a thorough inquiry has been conducted, report has been given. And considering that, whereas as per the inquiry report submitted by the BDO, South Salmara Development Block, it has been found that the allegation raised by Paresh Chandra Das regarding non-convening of Gaon Sabha in connection with formulation of schemes of
That I've read.
logic. So
Yes.
direction
We
of
can
the
close this contempt.
logic.
Lordship,
We can close this contempt.
direction for completely.
Direction was just to consider your
Yes.
representation.
Yes, yes.
Yes.
If they have any remark, they can
You can
they can
challenge the
challenge
order.
logic.
Lordship,
But MS,
as they.
as Dev Leonard counsel for the petitioner, Mr. D. Nath, Leonard counsel.
I am appearing for the response number 3.
Learned counsel appearing on behalf of respondent number three.
My friend,
appear for the respondent number
1 minute has produced an order dated 31st October 2023, issued by the Principal Secretary to the Government of Assam, Panchayat and Rural Development Department, wherein it is indicated that after an inquiry received from the District Commissioner Karimganj, the allegations made by the petitioner are found not to be true. Stop. In that view of the matter, New Para, we have the considered opinion that the respondents have complied, have substantially complied with the order passed by this court in PIL number
45.
22.
according contempt petition is closed. Mr.
Hey, that's for respondent number 1.
On top.
Lordship,
Press for respondent number 1.
Lordship may give us liberty if any, if to challenge the.
Accordingly, contempt petition is closed. However, giving liberty to the petitioner to approach the applicant for if further agrees by the order dated 31st October 2023. The order dated 31st this October 2023 is placed on record.
But one thing I must indicate, sir, well, the authority has informed us telephonically, there is a typographical error in the order. Instead of South Karimganj Development Block, it is typed as South Salmana Development Block. So in the last paragraph, no?
First line of.
The South Salmana Development Block, instead of that, South Karimganj Development Block. Well, they have informed us it is a inadvertent typographical error. No? This they have already taken care.
Okay.
All right.
9.
Made please, Lordship. As per last order, I have taken fresh steps upon the respondent number 8, madam.
So far as respondent number 6 and 7 is concerned, my lord, I am filing my wakalatnama today for these 6 and 7.
In the IA?
IA, madam. Notice to IA.
Respondents 6 and 7.
6 and 7.
And any other respondent?
8 has not been served, my lord. 2, 3, 4, and 5, I have filed my objections.
2, 3,
4, and 5, I have already filed my objections.
1.
8 is not served.
How about 8?
8 has not been served.
Has not been served, madam.
There is an office note, my lord.
Yes. 8.
Yes, madam.
I think October it was gone. Notice has gone on 16th or something.
October.
16th of October, I think, my lord, notice is gone.
Madam, let it come after 4 weeks, madam.
Not 4 weeks, after 2 weeks. Notice we went on
8, madam.
8th of October, isn't it?
16th of October, I think.
16th of October. We'll list it after 3 weeks.
Yes.
Heard in Mr. NG Katanil and the council for the applicants. Stop. Mr. SS Roy Leonard CDC appears for the opposite party number 1. Stop.
And Deca for 2,
Mr. N. Deca, Leonard
2, 3, 4, and 5.
standing counsel.
Not standing counsel.
Leonard counsel appears for the respondents 2, 3,
4, and 5.
4, and 5 by filing affidavits. Stop. And Mr. H.K. Das, Leonard
6 and 7.
counsel appears for the respondent number 6 and 7. So, Para. Our service report on the respondent number 8, on the opposite party number 8, and release the matter after 3 weeks.
Obliged, Lordship.
Highly.
10.
Wait, please, Lord.
Yes.
Well, there's an IA for continuation of delay.
My lord, the delay is of 341 days as calculated by the registry. My lord, we calculated in 601. But by excluding the period of COVID as per the direction of the Supreme Court, my lord, the office registry has calculated 341. My lord, on the last occasion, my lord, this honorable court directed me to examine and obtain instruction whether my lord, a decision on identical issue my lord, has been rendered by this division bench. I have checked up, my lord, against that a review has been filed. The review is not admitted as yet. It is pending for admission. Now, my lord, the dispute is with regard to my lord, claim of the petitioner for making payment of some excess payment made to him, which is sought to be recovered by us. So, my lord, this matter, my lord, there are some decisions of the division inconsistent one another. So, my lord, we have explained the delay at paragraph 4 and 5. My lord, what happened, my lord? Learned Single Judge has given the direction to make payment to the petitioner within 60 days. We made payment, my lord. Petitioner has got the payment. But because, my lord, there is a, my lord, the Learned Single Judge has, my lord, has looked into the terms of the tender, which we follow throughout the country uniformly. There will be, my lord, different, my lord, there will be some inconsistencies in the tender clauses throughout the country. Therefore, my lord, we wanted your lordship to examine the matter. Lordship may like to examine, my lord. Delay, of course, is 341 days. Delay occurred in taking decision because the headquarters had to be referred, and then the authority has finally decided that make payment first, as directed by the single judge. We made payment. Petitioner has got the payment. But my lord, because some legal issues are involved, my lordship may like to examine this. That is the. We have explained the delay, my lord, in paragraph 4 and 5. My lord, if I can read the paragraph 4 and 5, my lord. Page 7. May I read it, my lord?
Yes.
My lord, it says the applicant begs to state that in compliance with the direction given by the land signature directly to process the bills of the petitioner within a period of 60 days from the receipt of the certificate copy of the order, they have cleared the bills of the opposite party petitioner. However, since the interpretation given by the London single judge is not in consonance with the character and purposive interpretation under which the contract was designed to actualize, and the applicant FCI has been finding it difficult to set any different terms in such other similar contracts, deholds the terms of the model tender form, which they follow uniformly everywhere, where the FCI operates appellants have been taken a decision in consultation with the legal and financial and other operator to assail the said findings of the London single judge before the division bench of the High Court. Now, then paragraph 5, the applicant begs to say that after receipt of the judgment on the parts of the single judge, the matter was processed to the examination at various levels. But because of the time frame given by the single judge in compliance, it was decided to first make the payment in terms of the directions given by single judge, and then take up the matter examination as to whether an appeal can be preferred before this honorable appellate court. Accordingly, bills of the opposite party writ petition process in terms of the direction given by the single judge were made. Thereafter, it was first examined by the regional level FCI RO Guwahati, which sought for certain clarification from the SA district office, and the same was sent, and thereafter processed at the FC regional office, which took 3-4 months. But in the meantime, due to outbreak of coronavirus pandemic, the officers of the operative division had to devote more time on ensuring food supplies, and therefore could not devote much time on the taking final decision in team. There was also very poor attendance, regular staff in office because of the restriction put by the government authorities, which also got the matter delayed for a long period of time. Recently, CAG audit raised certain queries in respect to the
Chaudhary, do you have any?
My lord, I am on the condonation of delay. They have filed one application for condonation of delay without explaining any delay, my lord.
So would you like to file your objections?
No, I have already filed one.
You file your objections?
Yes. Because judgment was passed on 26/9/2019, my lord.
Yes.
They have come on appeal now. And we have given our objection at paragraph 7 of our objection, lordship, page 18.
Yes.
So, my lord,
basically on merit, my lord.
No, that the respondent opposite party states that the statement made in paragraph 2 and 3 of the IXD are false and fabricated and hence denied. The respondent opposite party states that the contract between the appellants, applicants, and opposite party being a contract and handling and transportation, the distance between point of loading and the destination point is a determining factor in calculating out the carrying charge. It was the contract of carrying charge. In the NIT, this distance was notified at 7 kilometers. Now they are claiming it is less than 5 kilometers. So that is the dispute. And in the NIT, I'll show your lordship.
No, that is on merits.
On merits,
But on the continuation.
But so far the delay is concerned, for our calculation, it is more than 600 days, my lord. And they have explained the delay of 341 days. That explanation is also not acceptable in the sense that they are referring to COVID. But what happened before COVID and after COVID, they are totally silent. Even not explained.
When was this application filed?
Oh, my lord, we filed it on 7/12/2022. Registry has calculated in 1041
Lordship
days.
may kindly come to.
My lord will see the registry's note.
5/6/2023.
Delay no.
You filed it on 5/6/2023.
7/12.
No, 7/12. 7/12/22. That perhaps is the date of the
Filing.
We filed it on 7th of December 2022. Our IA.
According to this, it is 5/6/2023.
No, my lord. 5/6. We filed it 7/12. Huh? 7/12/2023.
What is there in here? 5/6/2023.
Let's refer freedom.
Let me kindly come to paragraph 5, where I have explained how they have failed to give the full explanation to any detail. So, read, my lord. At page paragraph 5 at page 17. Lord.
Just, this is filed in June.
No, my lord. According to us, we filed 7/12/2022. Maybe, my lord, after filing, there may be some objection from the
Exactly, that's what I'm saying.
maybe for defect in typing and all.
In your affidavit, it is.
My lord,
that have been
15/6 it was listed.
Yes.
Well, after correction, maybe my lord, some defects in typing.
It came out on for the first time on 15/6.
15/6. My lord,
It was
there may
filed
be
on 5/6.
we filed it on 7/12/2022. Maybe some the registry raised some objection to the typing, my lord. That was cured, and the filing was done
So
well.
what is your explanation post-COVID?
Post-COVID, my lord, in fact, post-COVID, yes, of course, my lord, because after the COVID, the officers basically walked, my lord. Therefore, my lord,
Have you given any explanation on
we have
post-COVID?
said, we have given, my lord. No, specifically, we have not given.
Yes.
We said,
Then in the absence of any explanation,
no, we have said, my lord, that during the COVID, the officer, nobody walked. After that, we walked. And therefore, that is we have said. After that, we have only walked and promptly given the payment and all. That's what we have given within 60 days. We have made
you are
payment.
supposed to make a day-to-day explanation
My lord,
on the delay.
No, my lord, if you go by the Supreme Court said day-to-day need not be, the explanation not be sufficient. But after all, my lord, it is of my lord, office takes some time, my lord. Therefore, it is a policy decision. It had to be referred to the headquarters. Then, my lord, because what happened, my lord, this standard clause has been interpreted in a different manner. This standard clause we follow throughout the country.
What if it is, we're not into the.
All right, my lord, if you lordship so desire, I can file a better affidavit, my lord, some supplementary affidavit to explain the. Because, my lord, we have explained it. We have said since because of the COVID, nobody walked. After that, people walked. And then because it had to be. After all, my lord,
it is FCI.
My lord, the petitioner has got the payment, my lord. Petitioner would not be prejudiced. He got his payment.
In the entire country, how can it sit tight? It's not acceptable.
Petitioner has got the payment, my lord. Petitioner will not be prejudiced
No,
because
I have objection, Lordship. They have withheld my security deposit. It's a
Okay.
huge amount, my lord.
no,
They
no,
are-
direction was complied with.
It's misleading. Direction was complied, but afterwards, they withheld some other money.
No, that is
After
because of
so-
other contract.
after so-
That other contract.
Such
That
a-
is not related with
Then
this.
after
That we'll
such,
see. That we'll see later on.
Lordship,
But today is on the continuation.
No, contradiction. My lord, what I find, my lord, lordship, I think, my lord, the explanation as given, my lord. True, day to day is not given. Day to day is.
Explanation is not satisfactory.
No, that is all
particularly-
right, my lord, but my lord,
Particularly post-COVID time.
post-COVID
larger
time,
chunk
we have
of delay,
said,
They have no explanation, but larger chunk of delay.
no, my lord, that is true, my lord, the day to day, we have not said, because it said, because of the officers are not there, they took some time. That is because officers just to go
Some
to,
explanation should be there.
all right, my lord, lordship will allow me to
My
file a
lord,
better affidavit. my lord. I'll file it.
Lordship, they took so much
Because
of time.
for this delay, I cannot, need not be, the organization may not, need not be, may not non-suited. Lordship will,
It should fail on the ground of delay itself.
I'll file a better
Because
affidavit.
Already my party has
Once you
suffered.
find a better affidavit. How can you find a better?
My lord, explaining the later part. This later part is not, my lord, day to day I have not given. After I explain the later part. my lord.
Okay, let me find the affidavit. Let's see.
That being the admitted fact, Lordship, this should go. This should not be accepted, Lordship, because I have shown how.
At least let me find the affidavit, then we'll
Last-
consider.
no, no.
Mr. B.K. Roy. Counsel for the applicant. Please, for how much time?
10 days time.
Wait for 2 weeks' time. To file an additional affidavit. Explaining the delay in filing the connected reader. Yes, after 2 weeks.
Deep to
11 of supplementary list admission.
This case, your lordship, we have filed our IA, your lordship. IA, your lordship, inadvertently failed to make the prayer for stay of the impugn order, your lordship, honorable single judge order. And in fact, your lordship, this in fact, your lordship, we have to file it because your lordship, the order has greater ramifications all over the country, your lordship. The issue is like this.
Where's the order?
The judgment that has been passed, your lordship, is at page 109, your lordship. It starts from 109.
Yes, Devi, are you agreeing?
40 and 4.
Ultimately, your lordship, because of this order, your lordship, the problem that has come up, your lordship, in some tribunals, your lordship, the cases are at the final stage, your lordship. And now if this, on the pretext of this order, your lordship, judgment, your lordship, these will have to be, your lordship, ultimately transferred again to the, and there is no provision for automatic transfer from the DRT to civil court, your lordship. That's the problem with this, your lordship. Now, if your lordship comes to the judgment, your lordship will find that the honorable single judge, para 20, your lordship, onwards, para 20, your lordship, last part, your lordship. Under such circumstances, court is of the opinion that the central government in right earnest is required to do the needful by issuing appropriate notification. Now that process is, we don't know, your lordship, it's going on probably, your lordship, but your lordship, ultimately, if it remains, your lordship, this will have a ramification for the all the banks, Your Lordship, not only the Canara Bank, Your Lordship. That for limited purpose, Your Lordship, we have to file this seeking adjudication by this court, Your Lordship, and stay of the impugned judgment, Your Lordship.
Let notice go,
Lordship,
then interim will consider on the reasonable date.
Lordship.
But Mr. S. Bhatt, in the IA, learned counsel for the applicant. So, issue notice. MS R. Devi, learned CEC, appears for the opposite party at 3 and 4. Applicant to take steps for service of office on the opposite party 1 and 2 by which within 1 week.
Lordship.
1 week. Yes. 4 weeks.
If one observation can be made, Your Lordship, this order will, Your Lordship, remain confined to the case in the present
No,
case
that
only.
I'm not mentioning right now.
Lordship.